Dear Chief Acosta, there have been a series of robbery incidents in our community. We reported the matter to the barangay and the police, for which a conference was held to gather information regarding the culprit. All accounts of the witnesses point to one of our neighbors. Incidentally, his father attended the conference, but he immediately left the meeting. On our way home, we noticed that he was disassembling what seemed to be a ladder, and when asked, he said that it will be used as firewood. We suspected that it was the ladder used by his son, the suspect of the robbery, to commit the crime. We do not have any evidence that the father is also a robber, but can we at least include him in our criminal complaint against his son for destroying the evidence that we can use to indict his son? Thank you very much. Thelma.
Dear Thelma, as a preliminary consideration, Article 19 of the Revised Penal Code provides
Article 19. Accessories. Accessories are those who, having knowledge of the commission of the crime and without having participated therein, either as principals or accomplices, take part subsequent to its commission in any of the following manners. 2. By concealing or destroying the body of the crime, or the effects or instruments thereof in order to prevent its discovery.
In this regard, the father of your neighbor may be considered as an accessory to the crime committed by his son by destroying the ladder, an instrument of the robbery. He cannot, however, be held criminally liable under the Revised Penal Code because Article 20 of the Revised Penal Code provides for accessories who are exempt from criminal responsibility as follows.
Article 20. Accessories who are exempt from criminal liability. The penalties prescribed for accessories shall not be imposed upon those who are such with respect to their spouses, ascendants, descendants, legitimate, natural, and adopted brothers and sisters, or relatives by affinity within the same degrees, with a single exception of accessories falling within the provisions of paragraph 1 of the next preceding article.
On the other hand, the father may be held liable under Section 1, Paragraph C of Presidential Decree Number 1829 or the decree penalizing obstruction of apprehension and prosecution of criminal offenders, which provides that
Section 1. The penalty of prison correctional in its maximum period, or a fine ranging from 1,000 to 6,000 pesos or both, shall be imposed upon any person who knowingly or willfully obstructs, impedes, frustrates, or delays the apprehension of suspects and the investigation and prosecution of criminal cases by committing any of the following acts: altering, destroying, suppressing, or concealing any paper, record, document, or object with intent to impair its verity, authenticity, legibility, availability, or admissibility as evidence in any investigation of or official proceedings in criminal cases, or to be used in the investigation of or official proceedings in criminal cases.
in view thereof, the father may be held liable for obstruction of justice because Presidential Decree Number 1829 did not provide for relationship as a ground for criminal exemption. Note, however, that in order for the father to be liable for violation of PD number 1829, it must be established that he destroyed the ladder for the purpose of suppressing it and impairing its availability in evidence in the investigation of the crime allegedly committed by his son. As held by the Supreme Court in the case of People of the Philippines versus Padiernos, penned by the Honorable former Associate Justice Arturo Brion, wherein the accused was charged with violation of PD number 1829 for driving away a truck which was apprehended for carrying lumber without proper permit.
PD 1829 addresses the necessity of penalizing acts which obstruct or frustrate or tend to obstruct or frustrate the successful apprehension and prosecution of criminal offenders. Second, the petitioners deliberately took the truck or suppressed the particular evidence. The term suppress means to subdue or end by force. Specifically, the petitioners intentionally suppressed the truck as evidence with the intent to impair its availability and prevent its use as evidence in the criminal investigation or proceeding for violation of PD 705. This intent was duly proved during trial.
We hope that we were able to answer your queries. Please be reminded that this advice is based solely on the facts that you have narrated and our appreciation of the same. Our opinion may vary when other facts are changed or elaborated. Tomorrow, we'll look into another question from our viewers and readers of Dear PAO. This is your host, Dr. Presida V. Rueda Acosta, DSD, the Chief Public Attorney of the Republic of the Philippines. Goodbye for now.